Senator Surovell, you have a special immigrant juvenile status.
Thank you, Mr. Chairman. This one should be a lot quicker and
Senate Bill
simpler.
1181.
Thank you. So you all might remember back in 2019, we passed legislation that restored Virginia's juvenile court's authority to make certain factual findings that a child was abused, abandoned, or neglected for purposes of petitioning for a state or a federal benefit. That bill passed the state Senate 28-11, and the conference report on the bill, as a result of compromise with the House of Delegates, passed 38-1. And all this bill does is expands the jurisdiction of a court to make these types of findings through a child's 21st birthday. There are many children that get that don't realize that they need to go through this process until they turn 17, and sometimes lawyers will not take their case because they can't get them through the system fast enough. The pandemic has created delays with cases. Every case involving a juvenile like this requires a guardian ad litem report. Oftentimes a child turns 18 and realizes that they need to do this after an immigration petition is made, and there are about, I think it's about a dozen states now that have extended the jurisdiction to do these types of cases to age 21. And this bill basically just says that if you file a petition before you turn 18, the court can hear it up until the time when you turn 21 years old. So it's a slight extension of a policy we passed back in 2019, and I believe there's a few people who want to testify to the bill, Mr. Chairman.
Okay, anybody in favor of supporting the bill? Any question of the patron, first of all? Secondly, anybody in the public would like to speak in favor of the bill? Raise your hand. Okay, Hussein Hamad.
Thank you. Good morning, members of the judiciary. My name is Hassan Ahmed, and I'm a 14-year resident of Loudoun County, member of the Virginia State Bar, and have practiced immigration law for nearly 18 years, and I'm here to testify in strong support of SB 1181. The bill fixes a hole in the law by bringing state requirements closer in line to federal requirements. Federal law allows applying for SIJS by age 21, requiring these young people, as the senator said, to abstain a state court predicate order before turning 18 creates a wholly unnecessary race against the clock for those lucky enough to know that they're in a race. I myself have had several clients unable to obtain that predicate order by their 18th birthday, and some of them had to move to different states where they could obtain that predicate order between the ages of 18 and 21. The states that have raised the age to 21 with various provisos include California, Colorado, Connecticut, DC, Hawaii, Maine, Maryland, Massachusetts, Mississippi, Nevada, New Jersey, New York, and Washington. The jurisdiction of JMDR courts to issue predicate orders was fixed, as Senator Surovell stated, but the law still doesn't quite match up to the federal allowance. Maryland went through this realignment in 2014, and the same arguments apply in Virginia. This is a child welfare bill. It helps provide a responsible adult to a teenager during an at-risk time, reduces teen homelessness, provides a life rope to young people who are still trying to acclimate to a new life in America, and helps heal real trauma. Where a federal pathway exists, it is good policy for a state to provide an on-ramp to that pathway, and that's what SB 1181 does. Thank you.
Okay, thank you very much. Raise your hands for who would like to speak in favor. Andrea Margonis, is that right?
Yes, Andrea Mangonis. Thank you very much, Mr. Chairman and distinguished members of the committee. My name is Andrea Mangonis, and I am the managing attorney of the Washington, D.C. and Virginia Office of Kids in Need of Defense, or KIND. I support SB 1181 to extend jurisdiction of Virginia's Juvenile Domestic Relations Court for youth seeking special immigrant juvenile status related findings. KIND is a nonprofit organization that provides free legal and social services to unaccompanied immigrant children who come to the United States alone without a parent or guardian and who are facing deportation. KIND has been serving children living in Virginia since 2009, and in 2015 opened a Falls Church office. The DC Virginia office has screened over 1,000 Virginian immigrant children and matched 780 with free attorneys. We have extensive experience serving the population this bill will positively impact. Many unaccompanied children come to the US to flee violence, abuse, neglect, persecution, or exploitation. Accordingly, a large majority of those children qualify for legal remedies such as SIJS, which applies to youth up to age 21. SB 1181 will assist in starting to align Virginia law with federal law to maximize protections accorded to these vulnerable youth. Kind staff often encounter siblings in Virginia who made the dangerous journey to the United States together, fleeing for safety from the same exact parental abuse and neglect, and have to tell this family that the younger child, one of them, has a path to permanent status and stability in the United States, but the older child, just because she is 17 years old and won't be able to get an order from a JNDR court before her 18th birthday, does not have that same path, even though she is eligible for it under federal law. SB 1181 can be the difference between deportation and citizenship for that older sibling. Earlier in the discussion, the delays caused by COVID-19 in Virginia courts came up. Similarly, Kind is assisting a young man who filed a custody petition in March 2020. His first opportunity for a hearing is next week. Without a law like this, because he has already turned 18, he may be precluded from a lifetime of protection and status. Kind also has 11 field offices nationally and can firmly attest to the positive outcomes for clients in states with similar laws, as the person who testified previously spoke to. This law would serve the Commonwealth's interest in preventing further victimization of vulnerable youth, decreasing reliance on public resources, and maximizing positive community integration for immigrant youth who are already here and subject to the jurisdiction of the JNDR courts. Thank you very much.
Okay, thank you. Amy Woolard, the Legal Aid Justice Center. Amy Woolard, if you're there. All right, who else would like to speak? Raise your hand in favor of the bill.
Woolard's not on.
Huh?
Excuse me. Amy Woolard's not on,
Okay, all right.
Mr. Chairman, but I'm Sophia Gregg from Legal Aid Justice Center, and we support SB 1181 as well. I also teach the Immigration Law Clinic at the University of Virginia, and we ask that you all support SB 1181 as it removes some of the state barriers that inhibit most vulnerable in Virginia from obtaining this humanitarian immigration protection that you're going to hear about from the other advocates and people who have directly experienced the benefits of special immigrant juvenile status. So what this issue, the issue that this amendment attempts to solve is that under federal law, as you've heard, a child may apply for special immigrant juvenile status, the status that was created to help orphaned immigrant children who come to this country obtain protection for permanent relief from deportation and ultimately citizenship prior to the age of 21. And they need to get a state court determination that they've been abused, abandoned, and neglected in their home country. And unfortunately, Virginia law currently doesn't mirror the federal provisions, and the JNDR courts only have jurisdiction to conduct these factual findings once for a child under the age of 18. This misalignment results in young immigrants who do not receive the crucial findings before turning 18, and then they are forever foreclosed from this permanent protection from deportation and other benefits.
Yeah, thank you very much. I think the bill is in good shape. Is anybody in opposition would like to speak? If not, Senator Surovell. Move to report.
I move to report the bill.
Okay, so it's been moved and seconded to report Senate Bill 1181.
Mr. Chairman,
Yes.
I'm just curious, doesn't a bill like this have to go to finance? There's significant cost associated with it, I assume.
No.
Apparently not. Nobody's asked for it to go to finance. All right, all in favor of the motion to report Senate Bill 1181, vote aye. All opposed, vote no.
Ayes 9, nays 4.
Ayes 9, nays 4. The bill is reported.